parties and counsel are present. Our jurors are not present. The purpose of this hearing is basically, I guess, a discovery hearing with regard to when Dr. Rudin changed his opinion and how that was communicated to the various parties. So Dr. Rudin can resume this hearing. No, he's still sworn. And Ms. McGee, you may begin.
Thank you. Dr. Rudin, you testified on February 5th of 2019 concerning your findings in the 402 hearing. You remember testifying in that hearing?
Yes.
And subsequent to that hearing, you went back and did further analysis on the evidence that you have in your possession at that time. Is that correct?
In some very limited way, yes.
And in what ways did you do further analysis?
So, I think in the interim there was a request for validation of some kind from defense. So that was how should I say, what's the word, impetus, something, I'm not sure my English here. In other words, the source of my renewed energy on this. There was one of them, so I was trying to find something different, independent from the way I did things, that could validate what I did, number one. And number two, at the hearings, I was only able to present what I call 10-point case. And the reason for that is, well, the main reason, of course, there was not enough time to do all of that, but only 10-point case I was able to do measurements prior to the hearing, because that whole thing was new. So I just got into that laser scan of the street and finally was able to use it, and I was able to do some measurements, and I was not very happy with results. It was kind of a border case, and I was not that satisfied with that. So then I went and I checked the 8-point case and the 5-point case. And to my surprise, the measurements came very short, much shorter than the other one. And so they should have been consistent. So that made me think that there's more to it. It's not just an error. It's not just a data error of some kind or algorithm error. There's much more to it. And so that's what I started thinking about it. And then I realized the measurement can be shorter than it should be because the vehicle is actually underground. So it was absolutely unexpected because visually I could not say that. I mean, we knew that we need to look for unusual positions, and so that was a revelation. And then I realized that that's what was going on, that the vehicle was underground. And if the vehicle was underground, that means, and you have to look at this frame 76, whatever, 77, the third point, what we call the running light, is right at the threshold. But if the vehicle is underground and the point is on the threshold, that means that if the vehicle is on the ground, you cannot even see that point. Okay?
And you're referring to the third point. You mean the point down to what you assigned to the rear marker light on the rear side of the white truck.
Yeah, yes, that's the point. And so then I, just by pure logic, oh my God, I mean, this point cannot be seen. And that completely puts everything in question. So everything is coupled actually. So the length is too short, doesn't necessarily reject the model. So as I said, there's a configuration, there's a model, and then there is a point choices. And that's called configuration. If I have a completely right model, and it's the right model, everything is great, and I chose the wrong points, I would get an error which could be too short, too long. In this case, too short because it pushed it on the ground to basically to please that point. That point could not be seen. So what did the method do? It pushed it on the ground. So I realized that, and that was, okay, so we have a problem. So, and I realized the only way to resolve this problem, and then I tried another method, and at least preliminary at that time, and later it became much more formal in the last, I don't know, in the last months or so. We can confirm, in fact, that, but we already had preliminary result at that point. Very quickly, there's a matrix computation. I can figure out actually whether it's sitting on the ground or not. So whether z is greater than 0 or z0 is the ground level. And we figure out z is less than 0 because the gravity, one of the points on the bottom sunk and the whole thing tilted. So we already knew that. That was okay. And then there were some other rough calculations that I tried to, and that's kind of sophisticated stuff. And then there's some rough calculation I tried to do comparison with something called day vehicle. And that also kind of was revealing because that also pointed that point, third point, cannot be what we thought it was. Because if it was, the distance, which was about 5 feet, would drag the vehicle all the way to the curb. And at the curb, if you make a measurement of where it would end up, roughly calculating, roughly just sketching. I made some sketch at the time, and so roughly it was too short again. So again, everything was in flux, and I realized that we need to redo everything. And the way to redo it was to go to experiment. That was the best. I mean, because if somebody let me do this experiment way back, in 5 minutes I would know that the third point cannot be seen. In 5 minutes, that would take me just 5 minutes. I would just take a measuring stick, go to the curb, and reproject back to the original video, and I would see the mark where the overhang is crossing the measuring stick, and I would know that it's roughly, which we confirm later, is about 4 feet. Give and take, I think it's 4 point something. So, and the other one is 5.1 on the vehicle. So again, it all was pointing towards experiment, and they need to redo this whole thing. I don't know if I giving too long of an answer.
Let me see if I can just make some things clear. We talked about the third point being the preliminary, or being the marker light that's on the side. You said the preliminary findings were that the Z measurement was below 0. And I assume you mean by the Z measurement is that would be the place in reference to the ground, so a negative number would show that that placement would have to be below ground.
Yeah, the wheels dropped underground.
Okay. And that you're able to confirm after the fact within the last month?
No, already, well, depends what you mean confirm. It was, once I understood that, it was confirmed just by the fact that the length was shorter than it should have been. The only way the length can be shorter, if you look at the projection thing, so if I am projecting something as a cone, and it's supposed to hit somewhere under here, and that's like 10 feet, the way it's going to hit here is going to be maybe 9 feet. That's just the geometry of it. Once I understood that, everything was clear.
And then the second part you made about the view from the camera, when it's looking out towards the street, it had that overhang that blocked its view.
I think you're going beyond the purpose of this hearing. The purpose of this hearing is not for him to explain the difference, how he reached a different conclusion. I assume you're going to do that.
Yes.
Someone's going to do that in front of the jury, so we don't need to go through all of that. The point of this hearing is at some point he communicated with various parties about his change of position.
Yes, I'm just making sure the record's clear what he's trying to describe, because I understood what he said, because now I've had a couple conversations with him, meaning I had him testify and I had lunch with him. Other than that, I just want to make sure if people are going, I don't understand what he's referring to, I know what he's referring to. Just trying to put it in layman's terms, so if anybody reviews this, says, I get what they're saying. So I'm just trying to summarize.
I think there's an adequate foundation as to the fact that he changed his opinion.
Okay. So after you realized that that the placement of the vehicle would be underground and the view from the camera would not be able to see that marker because it doesn't have that range of sight, did you inform anyone from the government, whether it be a detective or a district attorney or anybody, about those issues?
Yes, I made a call to Deputy DA, Mr. Imes, when I was in Northern California at exhibit, technical exhibit, and I told him that we have a problem.
When was that phone call?
Let's see, I have to look at the dates. I think the week, I have to look at the dates. Can I?
Okay.
So if I remember correctly, my testimony was on the 5th
Correct.
of February. And so I left for Northern California on, I don't remember, on 8th or 9th or something like this. And maybe 9th. And I came back on the 14th. So, wait a minute. No, I drove on the 14th, or I came back on the 14th. I'm not sure. So I spoke to Mr. Imes, I believe, on the 14th. It's either 13th or 14th, last time, 14th.
Of February.
Of February. And I must have called him on either 12th or 13th, maybe 13th.
Okay.
Roughly 13th, I would say. Give and take one day.
And what did you inform Mr. Imes of during that phone call?
Basically what I said, that there is a problem with this conclusion, even though my conclusion was not exactly yes, it is this, or I did not even use the word consistent. I said I cannot reject. So at that point, my opinion went to the other direction, that the way I see it, I have to reject, and we need to do an experiment, basically.
Did you tell Mr. Imes that your opinion was now leaning towards exclusion?
Yeah, I remember I said literally this, because we went back and forth, and he said, are you sure, because I used different arguments and different, like I said, I had some rough argument, like rough calculation, and then I had this more precise thing, which is, hey, I know why we are getting this length, which is too short. And I even said, if I am wrong and we do this experiment, and we can actually match these 3 points being the front lights and that other light, I said, I'm going to retire. I said that to him. And at that moment, I thought it was the wrong thing to say, because I basically discouraged him from doing this. But the truth is that, anyway, the truth is that it did not exclude the model. It just excluded the light. I mean, if we could, it just excluded that light. Okay, that's what it turns out to be. So it didn't exclude the model, it excluded the light. But that was enough to get that letter next day on the 15th when I was told, you know what I was told, so.
What were you told?
I don't know what you were told. Yeah, go ahead.
Well, I was basically, if I could, I was told to stand down, basically. If you look at this letter, that's what it is, to stand down.
Do you have a copy of the letter?
Well, I'm sure Mr. Imes will be happy to give you this letter.
Did he tell you to cease and desist all further activity on this?
Well, he didn't use that word. He used something, we will ask you to stop the work. Yes. And also that there will be no experiment, which I thought there would be experiment because that's what we discussed when I was driving and talking to him.
Now, if I can have my computer on the overhead. On February 15th, 2019 at 10:44, oh, is that, no, nice. Barely put it all the way in. That might help. There we go. Mr. Imes emailed the defense team in response to my discovery request. The first part, the 5 were the items I requested in his response. And then the second part dealt with the discussion that you had, starting with because of the inquiry. Please read that paragraph.
The one that says again, a lot of this.
Above that.
Oh, that whole thing?
Yeah, the long one.
Are you checking my reading skills?
Read it to yourself.
I don't know that it's necessary for him to read that.
Well, my question is going to be the last sentence.
However, at the end of the day, we will continue to mention laws related to sexual. Yeah, it's actually accurate.
So the data points continue to match.
Yeah, of course. I explained it today from a matching point of view. If you don't use the other test, the match, the reprojection, right? There are 2 tests, the reprojection test versus the other test. So for the reprojection test, it's correct, they all match. But from next point on, when we started to use a laser scan, that's when the problem showed up.
Is anywhere in that discussion or the email explain the problem you had about the shorter measurements and the vehicle having to be placed underground based on the Z measurements that you got when having the marker light still being marked in that 10-point comparison?
Are you talking about this particular paragraph?
Yeah. Or anything you see there, does that show that you're now saying there's a problem?
No, but he said something about distances somewhere, which is related. I'm pretty sure that he did.
It's the paragraph that begins in one aspect.
Leave a sentence.
Where?
It's the sentence that begins in one aspect. It's 4 lines down.
Oh, okay. In several respects, he was able to do based on his projectors. One aspect, however, he was unable to validate over the lenses, but then it is gone. Yeah, okay, so he did say that.
So that's the length of it, but that's not it being placed underground, is it?
But it's related to that. It's all related. I mean, this whole thing is related.
What's the date of this email? on there?
February 15th. And I have a copy of it here for the court, just so the court can have a copy of it.
We'll mark that as court's exhibit. We marked court's exhibit N as in Nora, or no.
there was another note that went between me and Mr. Imes when I clarified more, because I don't know if you know about that note, but that was clarified in that note, which was, I never seen this letter before, I mean,
Right.
until I saw the letter just a few days ago or something. But in that letter, I remember the date. Can you scroll up?
Well, this is just the email he sent me.
Right, so I believe he sent you this email on the 15th, which
Correct.
was like at 10:44. And by, I don't know what time, a few hours later, because we had some exchange, and I said to him something to effect, I want to make sure that whatever it is you report is what we agreed, what it is. And so at that point, it was right after this letter, I specifically mentioned Z less than 0. And that was maybe just a few hours later. Just a few hours later after this letter. I mean, I have a record of this SMS, so if anybody wants, I can just instruct it.
I don't have it.
I'm sure Mr. Ives does.
So you have that note or whatever that you wrote to Mr. Imes with you? Because I don't know if we have that one.
You're confiscating my phone. You want to see it?
Yes.
Okay.
Right. That's true. Is it email or text?
Two text. There's no Perry Mason here. I mean, it's pretty much consistent with what he wrote. It's just a different way of putting it.
So, for the record, reading the record since it's on his cell phone.
Well, can you print it out?
Well,
No.
Yeah.
I don't.
Yeah, I can send it out.
Can you clarify that number?
Can you clarify what number that was sent to you?
Yeah, sure. I can go, how do you do that here? So it must be this number.
It's the San Bernardino DA 3 times and it has a mobile number, correct? And I don't know Mr. Imes' number, so if that,
What do you want?
go back
Go back to
to
the
that.
email,
It's not email, it's,
message.
Is that Mr. Imes' cell phone?
I would think so.
Ms. Rodriguez?
I know what it is.
You want me to send you a copy of that somehow? Yeah, why not? Yeah. Let's see. It's iPhone, you can do anything.
Yes.
Just with witness conferencing.
Wait one second, there must be a way. Oh, more, okay. More what? Okay. Two. Okay, who do we?
Okay,
What are the dates of these?
There's no dates on the ones you just printed out.
There are not.
Well, just a minute. So we just printed out something that Dr. Rudin indicated. You sent this to Mr. Rhines?
Correct.
And when?
15.
On February 15th?
Yes.
Okay, about, do you know about what time?
So I have this chain that starts on Friday. The reason I know it was, so there's a chain here. And then February 15 at 11:23, I told him that I just got his message when he said that. Told me that.
Basically when he said, stop working.
Yeah, all of that. And I think that maybe there was another message before, I'm not sure. And there was something, I remember vaguely, when he's saying that he, to the best of his understanding, he will explain what it is.
Okay, but what we have here, what we just printed out, this was sent on the 15th.
Yeah, it says actually here, Friday, February 15, 11:23.
Okay.
I said, no, that was prior message. I said, I got your message before you convey our basic finding statement. It would be useful if we briefly talk one more time to make sure it is accurate. Yesterday conversation was interrupted by the long distance during driving conditions and mountain ranges. Thank you. And then he responds to me saying that I kept the statement vague and based on my understanding of what you conveyed to me, but disclosed the key point, which was inability to validate your findings with lengths of chart, and that it came out short. I will free up time to talk later, but I have full day of obligations to make up for being in court all week.
And then that's when you sent.
And then I responded right away, so which is, I think was an hour later, or whatever. I was thinking of writing an email, but I was really, I don't know how to put it, certainly not, I was quite confused with what's going on. I have never seen anything like this before in my 30 years forensic scientist, being basically told to stand down when he's working. But anyways, then say, okay, I just wanted to clarify this point and send it.
Okay, and that's what I have here.
Yeah.
And that was at 11:23.
No, at 11:23 the chain starts. So at which point I exactly send that? It was that same day.
Okay, but within a few minutes.
Yeah, because usually the iPhone puts another date.
Right. Right, no, I
Not
understand.
necessarily minutes, maybe an hour, I don't know. I have to compose myself and think about what I'm gonna say.
Okay, that gives me a great basic idea. Okay.
Because I basically reported everything I've done in I don't know, in a Twitter format. Because otherwise I would have to write a long email and I didn't feel like doing it anymore.
Okay, let me read this for a moment.
And I never got a response to that.
Mhm. Yep. So this, then this.
Right, there you go.
Okay, okay, I've read that.
What do you want to do?
Yes, this will be marked as Exhibit O. And the court's Exhibit O is an ocean. You may continue, Mr. McGill.
So this information then was conveyed to Mr. Imes after February 15th at 10:44 a.m. when he sent the email to me. Because as you said, the text string started at 11:23 a.m.
Right. Yes, it must be up.
39 minutes later.
Something like that. Of course, I don't know if he ever got it, but because that's, you can talk to Apple people. iPhone. Never responded to me.
And the item or the details that you expressed in the last text message about the Z coordinate, the parallel curve problem, it's being impossible to fit and it's being in the ground. Is this the first time you conveyed that information to Mr. Imes in that text message?
No, I believe I talked about it when I was driving or whatever. My wife was driving and I was talking to him, but I don't know if he understood. And I asked for a meeting on Sunday, and we were supposed to have a meeting on Sunday. And I was going to lay down everything. Sunday or Saturday, I don't remember. I think Sunday, it says. And later it was all canceled. And in fact, we even arranged, I was trying to arrange live reprojection experiment on as early as Monday. I was going to cancel everything I had and did it.
And in relation to sending these text messages, when were you told to stop working and you were not going to be testifying?
I think on the 15th there is an email. I have a copy of that. And you know I'm going to be asked about that. It must be on 15 because the email says, because we're already talking about this, so I already know. So it must be the same day. It was on 15th that I got it, on Friday. Yeah, I'm pretty sure about it because I just read it here.
So on the 15th, you got an email from Hines basically telling you, stop work on
Mr. Hines, yes.
it. Okay. And that was after your text message or
No,
before?
no. It was before.
Before the text
Because
message?
why would I stop working if he didn't tell me to stop working?
Okay.
By the way, just because he said stop working, that doesn't mean I have to stop working.
I understand.
For all practical reasons, I did for about a month or so. And,
And just so we're clear, you weren't billing anybody for your time or your work on this, so it wasn't like you were trying to make more money by keeping it working, right?
No, it was a completely pro bono case.
Do you have the email from Hines when he said to stop work?
Yeah, I'm sure you have it. Kind of.
I can show the court a copy.
Okay, that would be good, thank you.
What's the date of that?
February 15th.
February 15th? Your Honor, we don't have a copy of that email.
Okay.
We were sent an entire packet of everything. We have up to February 14th and starting again on March 12th.
Well, I found it. It says, well, it's amazing. It's 10/17. So it was just before he sent the letter to
Okay.
Oh, Mr. McGee and other people.
So we'll mark this as Exhibit P as in Paul.
Well, if there's someone, a quote stand down there.
Okay.
Well, 8, he already took it. It's marked as exhibit. And Your Honor, just so we have the record clear to the exhibits in case that's lost. It says, Lenny, any further consultation with my colleagues, we have made some tactical decisions based on the information you have provided.
We have
One,
that, it's marked as an exhibit.
right, but in case the exhibit gets lost, we want to at least have a record of what was stated.
You're accusing our clerk of losing the exhibits?
Well, let's just say Mr. Moline might take it and forget to return it or something.
I think we have a record of it. You don't need to read it into the record.
Any more questions? Your Honor, we don't have any further questions of Mr. Rudin on this issue.
What was the last part? You don't have any further questions?
Of Mr. Rudin, or Dr. Rudin?
Okay, anything on cross on this issue?
Does this mark as an exhibit? What's on court exhibit N, I believe. Court exhibit N?
I believe that is in, correct.
Okay. Dr. Rudin, I believe you said several times, but I did want to make clear the summary here in this email that you saw that was sent to counsel, that's an accurate summary of what you told Mr. Imes.
You mean prior to the other attorney? Yeah.
I'm sorry, prior to what?
Prior to the message, MSM.
Okay, so, but up until that point, that's an accurate reflection of what you had told Mr. Imes.
Well,
It's a summary.
I'm sure Mr. Imes didn't study mathematics as much as I did.
Stipulate.
Okay, maybe he did, but different discipline.
No, he's actually agreed he did not, sir.
Oh, okay.
And so my question is, does that accurately reflect what you had told Mr. Imes up to that point?
I mean, there was more to it, but that was his understanding. I understand that.
And you would
Would it
agree?
be fair to say
That's
that
reasonable for somebody who doesn't understand all the intricacies.
That's exactly what I was going to ask next. It's a good summary for somebody who doesn't understand the whole thing.
No, he understands, but not. It's a deep stuff here. I mean, this is very deep, actually.
Understood. And this email, I think we've established, was sent before the text message that you sent to Mr. Imes.
Yeah. According to that 10:30, whatever. Yeah.
10:44 was this email, and your text string with Mr. Imes didn't
11
start.
something starts at 11.
11 something. Nothing further.
Okay, anything else?
From Dr. Rudin? No.
Okay, so we're done with Dr. Rubin for today?
I believe so, yes.
Okay, thank you, Dr. Rubin. You're excused for today. We are going to need you back at about 9:30 tomorrow morning. Hopefully, they've made some arrangements for you to be able to stay here instead of having to drive back and forth.
No, my wife wouldn't let me. Go home.
I understand. Well, they should have made arrangements for you and your wife to stay here.
They didn't know for that.
All you had to do was tell them.
Thank you.
Thank you. Any additional evidence by the people?
You mean by the defense?
Oh, I'm sorry, you had additional evidence?
Yes, Your Honor.
Oh, okay, I'm sorry.
We also received a bulk email packet from Mr. Imes, which is up on the screen now. What is not included in that packet was the email from the 15th, which is now marked as Exhibit P. I don't know if the court wants a copy of all the emails that were shared and discussions that were shared with defense counsel from Mr. Imes, but I do
Yes,
have
I do.
I do have a hard copy of that, and they are in date order.
Okay. So we'll mark that as Q as in Quincy. So I'm not going to read all of these at this moment, but I will read them before it's over. Okay, anything else?
And I believe, just so it's clear, I think these emails were received, I want to say it's April 23rd, but let me double check that date. Not right. Let me see which. They're sent to the defense on April 16th by Mr. Imes to myself and Mr. Moline and the rest of his defense team. Yes.
So these are emails between the prosecution and Dr. Rubin.
That's, yes.
And this is what the prosecution sent to you on April the 16th.
And I'm printing out that cover page from the email that was sent from Mr. Imes to me
Okay.
that show that packet.
Are there any other emails or communications between the prosecution and the defense on this issue?
On Mr. Rudin, not that I saw, no.
There is the I don't know what the court marked it as, but the February 15th email to Dr. Rudin was sent later. It was not part of the packet. I was present when Mr. Imes told Mr. McGee in court here.
Wait just a second. Okay, go ahead.
I was present when Mr. Imes told Mr. McGee that he found another one that he didn't include in this packet. We're searching for the email now. He sent it later. I want to say it was within either the same week or the week after.
Yes, he did tell me that there was other emails that were not sent part of the packet, and he would forward them to me, and I never received that email.
I think I did, and I think you were on it. So we'll find it. But
Okay.
But yes.
And I do remember a discussion in court, I have no idea the date, but where Mr. McGee raised the issue and, or maybe the prosecution raised the issue that the defense was trying to get these emails directly from Dr. Rudin, and I indicated it has to go through counsel, and Mr. Imes said, we sent it all, and Mr. McGee said, I don't think I have it.
no.
And Mr. Hines said, I'll send it again.
And that's the large packet we got. But he did come subsequent to that. That did happen. He did say, I found others that were not in the packet. Let me forward them to you, and those were never received.
I think it was just one. We're searching for the email now. So.
Okay, and is that the Exhibit P one that was referenced? Or?
Yes.
Is P the yes?
Then that should be that. Yes.
Email to Dr. Rudin.
Okay.
As for evidentiary issues, I don't think we have any further. We would have to research and figure out what we want to do next.
Okay. Anything additional that the people want to present? Other than finding the one email that you think you sent?
Yeah, I don't think, I think at this point there's been an allegation of misconduct, or at least sniffing around for misconduct. I find it hard to believe that this wasn't discussed.
I would say it is an allegation of misconduct. There's an
Right.
I understood it to be an allegation that basically Rudin said, I changed my opinion, and that was not adequately communicated to the defense counsel. That's what I understood the allegation to be.
And defense counsel said, at this point, we don't wish to make any allegation because we don't know what is being said. And I even informed Mr. Doctor beforehand. I was like, we're going to tread very lightly here because we don't know what we have. And I don't want to start making any allegations till I know what the facts are.
Okay.
And I asked Mr. Rudin, or Dr. Rudin, about specifics, and he was unwilling to give them. So I said, okay, I'll just wait. And then we will do this in a proper form to where we can have a better record of what occurred.
And so now we've done that.
Correct. And now I'll meet with Mr. Moline and Mr. Gerard and Mr. Merritt, and we'll discuss what we want to do going forward. But we have not made that decision yet.
Okay. And then obviously if the people have, if you can find that additional email, we'll make that part of the record as well, of course.
Well, no, it's now in the record.
No, I know, but where you say that you subsequently sent that as a follow-up.
Okay.
If you can find that, we'll make that part of the record as well. And then,
We are 7 days out from what we hope to be closing arguments.
I understand. And at this point, I probably would not be inclined to continue the matter over this issue from what I've heard so far. But I'll wait to see what, if any request is made and the basis for the request, and then obviously the people can respond to that and see where we are.
We do have requests, though, Your Honor. The request would be for this information to come out and present to the jury about what was told and what happened subsequently to that.
And how does that have any relevance to the issue of whether or not Mr. Merritt is the perpetrator of the offense?
Because as the court may recall from our opening statement, and we've said during this whole time, there has been a confirmation bias on the part of this government prosecution of Mr. Merritt. They ignore information that does not fit their theory. Now we know that information was presented to the government saying, our original theory is gone. We can't agree with that anymore. And I'm finding this is actually not his truck. And instead of giving that over and the details of that, they intentionally made it vague and then said, let's not call him and call somebody else. And they didn't tell the defense as to why that happened.
And we would have never found out about it.
And we would have never found out
Your
until...
Honor, excuse me, we're Mark Voss.
Please don't interrupt.
No.
We're not finished.
We're
He's
getting.
here about
No, it doesn't matter. He doesn't have a right to
The
interrupt.
cart's before the horse here. We're waiting.
He doesn't
for
have a
email.
right to
Let
interrupt.
him finish his presentation. Go ahead.
And so what we want to do is make that as part of our presentation, that information that was known that didn't match their theory is not being presented to this jury or being ignored and actually not given to our defense. And we should be able to present to the jury that the people knew that they had a retained expert, and that expert said, first, this is Mr. Merritt's truck, possibly, in that video, maybe not, it can't be excluded, it can't be included, to, yeah, his is excluded now. And oh, instead of saying, we might have the wrong guy, they said, let's go find somebody else that will tell us it's included. And I think the jury's entitled to hear that. They're entitled to hear they're cherry picking their witnesses and that they're cherry picking their evidence to say, let's convict a man based on information that we may know is not accurate, and let's hide it from the defense. That is the confirmation bias that we started this case with. That was my opening statement and my opening remarks is confirmation bias. This is what this case is about. And this fits that narrative. And that's why, based on that being the subject of our defense, we should be able to present what went on during this prosecution to the jury so they can evaluate not only the evidence, but also expert Licio testimony to know it contradicts something that they heard from another expert. And that's...
Well, you are going to be able to, you already started the examination in front of the jury that Dr. Rudin disagrees with Mr. Licio's conclusions and the reasons for those conclusions. So certainly you can present that evidence that Rudin says, I think Licio is wrong, here's all the reasons why I think he's wrong. You can present Dr. Rudin's conclusions that I think the truck is excluded, that Mr. Merritt's truck is excluded, and why it's excluded. But the so-called confirmation bias argument, I don't think is supported by the evidence. Literally within minutes, if not within an hour or so, Dr. Rudin first advising Mr. Rines that there is a problem. Mr. Rines sends an email to the defense. Actually, it's not within hours, it's within 2 days, I guess, because the initial conversation was on either the 13th or the 14th, and this message is the next day, the 15th. So Hines advises the defense there is a problem with Dr. Rudin's testimony or conclusions. He continued work on the matter to attempt to validate his initial findings. While he did validate most of those findings, there was one area he was unable to validate, and he was unable to validate the overall length of the truck compared to the known ferroscan length of the truck. And Dr. Rudin said that was what was related to his conclusion that the truck would be, in order to make that match, would be underground, that it did not now match, and that therefore the measurements did not match, and that there was an issue with regard to the pixel space on the Dodge truck. And Mr. Rines says, I don't know the effect of that on the validity, validating the data. And then Mr. Rines says, I only have a rudimentary understanding of this information, therefore I'm not the best conduit of the information. And says, therefore, we're only going to use Rudin in rebuttal. Feel free to contact Rudin if you want this explained further. So he's telling the defense Rudin is now basically changing at least part of his conclusions. He's saying the measurements don't match. He said the measurements of the length of the vehicle don't match. There's a problem with the pixel space, and I don't understand all the details. If you want Rudin to explain it, feel free to contact him.
Your Honor, you skipped a big point. However, in the end, all the data points continue to match, regardless of whether you do these point comparisons. He did not inform the court subsequent to this, the defense subsequent to this email. He got a very clear addition to all the problems.
That sentence was attorney opinion. It's irrelevant. It's irrelevant to their accusations of misconduct and irrelevant to their accusations of suppression. Your Honor,
Did I finish my
Let
sentence?
him finish, let him finish.
In Exhibit O, the text says, these are the 4 points that are a problem. And he laid them all out in writing. And Mr. Imes never forwarded that information to us.
He says that he did.
No. He said he forwarded the email saying that we fired him. He never said, and never been represented, that the contents of the text, which is Exhibit O, this was never given to defense, and they never represented that they gave it to us.
He just did. He said that they subsequently, when you discovered there was, either you reported or discovered there was one email that was not included, and they subsequently found it and sent it.
That's Exhibit P, which is the 6 points saying we're no longer going to use you, we're not going to meet on Sunday, we're not going to do the reprojection experiment. That's the one they said that they might have sent, but they got to check. That is totally and wholly different than Exhibit O, which Exhibit O lays out the Z-coordinate problems, the curb placement problems. It goes in detail. This was never forwarded or sent because this is a text, not an email. This was never given. And they made no representation that they did give this over. And these are the details that explain out everything, contrary to his admission in his text, I kept the statement vague. Of purpose intent to. I'm not going to explain the details to the defense so they get a full understanding of what you say your problems are. I'm keeping it vague. And then when he got more information, he decided to sit on it and not provide it. That the jury should hear about.
I don't think that is, assuming all of that is true, and of course the prosecution would dispute that, and then we would have several days of testimony with perhaps Mr. Imes and other people from the DA's office testifying to what they did or didn't do, why they didn't do it, you responding to what you got or didn't get, and none of that has anything to do with whether or not Mr. Merritt is a perpetrator. It's a collateral matter, and your request to present that information to the jury is denied.
Your Honor, Dr. Rudin also testified that that information in that paragraph is consistent with the text message that he sent to Mr. Imes.
I know that.
And he also confirmed the last line that Mr. McGee is adamantly saying that is incorrect. Dr. Rudin just testified that that last line that starts with, however, in the end, all of the data continues to match. He just testified that that was correct.
Well, clearly there was a significant change in his conclusion. That information that there was a change and a problem with his conclusion was provided to the defense. The defense then was encouraged to contact Dr. Rudin to obtain all of the details of that, which they did. And they now have it here to present. Now, if this were a situation where this occurred, it was never provided, and there was a conviction, and the defense doesn't discover any of this until after the conviction, and they're then asking for a new trial because of suppression of evidence, that might be a different issue, but that's not what happened here. So I find that in terms of relevance to whether or not Mr. Merritt is the perpetrator of the offense, all of this information is collateral, and therefore it's excluded under 352 because it's collateral. It would be an undue consumption of time to go into it, It would cause counsel to have to testify and put counsel's credibility before the jury, and would tend to confuse the issues to the jury rather than be helpful to them in any respect in terms of determining whether or not Mr. Merritt is a perpetrator of the offense.
Just one clarification, the court said, all this information, can you be specific so I make sure I stay within the confines of the court's findings and order? Like, I can't say, did you tell this to Mr. Imes, I assume, but I can go into the substance of the change in what he found.
Sure, you can, of course you can go into the substance of the change, because I'm sure the people are going to want to point out what he did testify to at the 402 hearing. So certainly you can go into, my original opinion was X. This is what I told the prosecution. I testified to that at the 402 hearing, which he's already done. And I subsequently changed my opinion. Now my opinion is Z. Here's the reasons I changed from X to Z. You can go into all of that. But when he told the prosecution of that, when the prosecution told you, that's not relevant.
For the jury.
Correct.
We think that the court also needs to make a finding today with respect to Mr. Imes, that it's unfair to make these accusations and let them continue to linger while we continue with this case. This particular witness is back on the stand tomorrow. And so to let that sit here and linger before the court while defense comes up with new schemes and concoctions and allegations that they want to make that they haven't been able to prove, the court needs to make a specific finding with respect to that based on the information that they received to date, because today is the day that was set for this hearing.
Well, as of this time, I'm satisfied that the exhibit, I think it's Exhibit N, the February 15th memo from Imes to the defense, where he details that there is a problem with Rudin's conclusions, that he's continuing to do work, that the measurements of the length of the truck do not match. There's a potential problem with the pixel space of the Dodge truck, and he only has a rudimentary understanding of this, so he's not the best conduit to provide all of that information, and therefore you should contact Rudin if you want this explained further. I think satisfies the prosecution's requirement to advise the defense that basically Rudin has changed his opinion, or at least there's a problem with his opinion. Now, if the exhibit Exhibit O is Dr. Rudin's follow-up, detailing, we're giving more details as to his oral report over the phone to the nature of the problem. That should have been provided to the defense. If it wasn't, they have it now. If it was intentionally withheld, that would be a violation of prosecution's Brady responsibilities. But at this point, there's no prejudice because the defense now has it and is able to utilize that information.
Your Honor, if I could clarify the last part of your ruling or inquire as to the court's opinion on that. Exhibit O, the people agree that it could be a Brady violation if it contained exculpatory facts, not opinion or attorney consultant communications or vacillating opinion or discussion of ongoing experiments. It would have to be, under the case law, exculpatory facts and intentionally suppressed, but as the court made clear, the defense has it. Therefore, as a matter of law, it is not suppressed. And as the court also...
I think it does meet the first criteria that you mentioned. He indicates other photographic method. We established a specific optimal pattern fitting computed 3D position is not a truck on the ground position, but rather offset with Z coordinate below the ground surface, parentheses, Z less than 0. Wait just a minute. Through further photogrammetric calculations, we established that the white truck parallel curb border position is impossible due to truck length fitting error, i.e. white truck is too long to fit at the curb border. I think that is exculpatory information. I think that Brady requires that to have been provided. If it wasn't provided, that is a Brady violation. If the trial had been concluded and it hadn't been provided, that would be a significant problem. But it was provided and discovered prior to the trial concluding, with the defense having the opportunity to present that exculpatory evidence.
Fair enough, Your Honor. I would add one thing, or ask the court to opine on this one thing regarding Exhibit N, the projected email on the screen right now, the email dated February 15th, 2019, 10:44 a.m. The large paragraph beginning with "because of your inquiry," that paragraph and the rest of the contents of the email presage all that you have just read as to Exhibit O. I believe the case law would uphold this as a full disclosure or sufficient disclosure to keep this out of Brady territory.
No, because Exhibit O was subsequent to Exhibit N.
It was. In chronology, that's true, but this large paragraph has a lot of speculative words in it, and there's no, in my view, there's no, Exhibit O depends on the assumptions that are mentioned in this exhibit. Let me call your attention to a few words here. Because of your inquiry and the fact that Dr. Rudin seems to never give up trying to solve the puzzles, he continued working on the material and attempts to validate the outcomes. He talks about comparing measurements. In one aspect, he was unable to validate the overall length, making certain assumptions. So there are contingencies built into this reasoning and into Dr. Rudin's opinion, and I believe that continues on into Exhibit O. And so I would just ask the court to keep it open.
No. Exhibit N is Mr. Imes' attempt to summarize a lengthy conversation with Dr. Rudin. And as Mr. Imes stipulated, he may not be the best conduit to relay all of the details and fine points that Dr. Rudin was attempting to explain. Exhibit O is Dr. Rudin saying, here's what my findings are. Here's what my new conclusions are. Here's what the problems I found with my original analysis.
Okay, fair enough. Would the court agree that its evidentiary ruling under 352 and the reasoning leading up to it equates as well to a finding of no misconduct by the people? Because that's what I heard in your reasoning leading up to your evidentiary ruling, that there was no misconduct.
Well, I think Exhibit N meets and satisfies the prosecution's Brady requirements up to that point in time. Almost immediately, the prosecution notified the defense that Dr. Rudin seems to be changing some of his opinions and conclusions, specifically with regard to the length of the truck not matching the known length of the truck in the Faro scan and the position at the curb. And telling him, I'm not the best conduit for this information, you should contact Rudin on your own. So I think at that point, that satisfies Brady. Once the prosecution receives Exhibit O, I think I'm satisfied there was a duty, is a duty to provide that.
And to clarify for the record, that I thought I heard the court notice that the defense is now in possession of Exhibit O.
They are now. I don't know when they got it. It might have been today.
So
Right now.
and the court has received the 6-page or 7-page brief that I filed just prior to this hearing on the people's
No.
opposition to Brady allegations.
No, I haven't seen it.
Okay, I would just quickly call attention especially to page 2, where I briefed that as a matter of law, where the material at issue is disclosed to the defense, there can be no suppression because here we are in trial. And from what I've seen, Dr. Rudin has become a defense consultant more than a prosecution consultant and a defense witness.
Well, I think that's probably true at this point.
Yeah, and so there, on the facts of this case, as a matter of law, there's no suppression under Brady. And without suppression, there's no Brady violation, and without Brady,
Well,
there's no
I don't
misconduct.
think anyone is asking for, there's nothing to suppress.
Well, it's not, there's no motion to suppress anything, but no intentional suppression, or I shouldn't say intentional, suppression of exculpatory evidence that's also material, favorable to the defense, is an element for the defense to prove and make a Brady allegation stick. Here there is no suppression because they're in possession of it. Dr. Rudin is now their witness, and they can do whatever they need to do. And in light especially of Exhibit N having been disclosed 90 days ago or more, I'm aware of no cases, no case law here in California across the country that would find or sustain a Brady violation on these facts.
Can
I ask the court to so rule.
We would like
Well, I
to
haven't
hear.
read the brief, so I'm not in position to rule whether or not failure to give Exhibit O to the defense constitutes a Brady violation. Now, it is true that Mr. Hines indicated, feel free to contact Dr. Rudin. It's clear that the defense, in particular Mr. McGee, has been in contact with Dr. Rudin. So they were certainly in a position to discover all of that information, specifically the information as to the specifics of his change in opinion.
Well, let's
To be clear, let me just finish one thing. To be clear, Mr. McGee also represented that he asked Dr. Rudin specifically about what he was going to say on the stand today and what information he received, and Dr. Rudin wouldn't give him that information. So if Dr. Rudin is in possession of this information that changed his opinion and didn't provide it to them when that's their witness, that's not something that's onerous to the people. And I would also note that Dr. Rudin testified that with respect to this text message, he has no idea if Mr. Imes actually received it because he did not receive a response. That's what's in the record and what's in evidence before the court.
Well, if the people are in possession of the information that Dr. Rudin was reluctant to share with defense counsel, that doesn't relieve the people of their duty to provide it if it's exculpatory information. There's two issues. Number one, I guess there's three issues. One, did the people receive
Exculpatory.
did the people receive Exhibit O from Dr. Rubin? Number two, if they did they ever forward it to the defense? Number three, if they did not, was it intentional or was it inadvertent? And then number three, at this point, while we are still in trial, is there any prejudice since it has now been disclosed and the defense has the opportunity, and clearly the defense for at least 4 weeks has been planning to call Dr. Rudin as their own witness. He was going to be testifying April 23rd or 24th with Mr. McGee doing the examination before Mr. McGee got ill. And then we gave Mr. Moline time to prepare to do that, and then we elected to wait an additional 4 weeks to give Mr. McGee the opportunity to do the examination. So clearly, at least since mid-April, the defense has been intending to call Dr. Rudin and have him testify to what his current conclusions are.
I think
So I don't think there's any prejudice.
I think what I'm unclear about, and perhaps what the prosecution might be unclear about, is Dr. Rudin testified that this email is essentially the same as this text message in layman's terms. This information is the same, it's just in vague terms. It's not as detailed as this.
Well, there's a significant difference between an attorney saying, I talked to this mathematician scientist. He gave me a lot of technical information. I only have a rudimentary understanding of it. So I'm not the best conduit, but here's what I gather is the bottom line of what he's saying, versus an email from the expert saying, in particular, here are the things that I told you. Even if the email is a rough layman's summary of that information, that does not relieve the prosecution of providing the subsequent email, Exhibit O.
And just so we're clear, a few things. One, Exhibit O is a text message between Dr. Rudin and Mr. Imes and not an email.
Okay.
So he could not simply forward that. He would have to recreate it and type it out and send it. So that's one.
Be forwarded as a text.
Yeah, but I don't think we have each other's text or phone number, so I don't know. Anyways, that being said, I want to address the fact of the prosecution's attorney saying that this is our witness. This is not our witness.
It is your witness. You called him.
Well, no. It's a retained expert of the people, as defined by CCP 2034.21, and also Easterly by v. Clark, which is at 171, Calip 4772. If it's somebody who's an expert, who's not a precipient witness, who's retained for the purpose of forming and expressing an opinion in anticipation of litigation, That's a retained expert. That is what he was for the people, and by the own email in Exhibit P, we may call you as a rebuttal witness should the defense call an expert. They're still retaining his services and still planning to possibly call
So what
him.
difference does it make?
Because I want to make sure that they don't try to make the argument that, well, since this is a defense witness, we had no duty. And that was, I think, the argument that was attempting to be made, and that's ridiculous.
Maybe you didn't understand me, but
I understood you, but I'm just saying, yeah.
I'm agreeing with you.
Yes, I agree.
That Exhibit O constitutes Brady material that they have a duty to provide. I don't know why you want to continue to argue that.
I'm making it very clear that it could not be labeled as our expert, which would be inappropriate. It's a witness we recalled, but it was not our witness or expert. The other thing I think that is also very important to realize is the context of prejudice. One, we only found this out because Dr. Rudin called us. We didn't contact him. And when he wouldn't give us the information, I had to do this hearing. But without this information, including it being impossible to place that vehicle in that proximity to the curb, and it would be underground, those issues I could have used on cross on Mr. Licio, the expert they called. This information came to light after the people rested, after they put on their entire case. To say that we have it now, we can't unring the bell, we can't unring the cross-examination of Mr. Licio. Mr. Licio, did you get the opinions that were provided to the people that you cannot align that truck that way to the curb? No, I didn't. Well, doesn't that impact that he says that they're your own expert, you're the co-expert?
I think you've made an adequate record of what occurred and what the communications were. So,
but the idea that there was no prejudice, the fact that, well, we found it before the jury's concluded, it affects our ability to cross, it affects how we could approach this investigation, whether or not we would have called witnesses, whether or not we would have done anything. We might have arrested and not decided to call our own videographer.
so what are you asking for?
I'm not asking for anything. I haven't brought a motion yet. I'm just trying
If
to.
you're not asking for anything and you haven't brought any motion, there's no issue before the court, so we're done.
Okay. I tried to do that before.
Well, apparently not, because every time I said I agree with you, you wanted to argue more, even though I was agreeing with you. I don't understand that, but
Your Honor, there is a fifth issue that hasn't been addressed, and
we need to take our break. We'll take our afternoon break, 15 minutes.